Hello, hello, hello. Welcome in, everybody. Welcome to the channel. Welcome in. Hopefully, you guys are having a great Wednesday. It's hump day, halfway through the week. Hopefully, you guys are having a great day, though. If you're new to the channel, hi, hello. My name is Tanya or TitaniumBuilt. You can call me either or. I don't prefer one over the other. But we are going to be covering Sarah Boone today. So she's in court. I forgot she even had a court hearing. I've been waiting on the trial to start on the 7th. So let's welcome some people in, and then we will talk a little bit about Sarah's new court hearing that she's going to be having. So did I? Oh, I didn't pin the message at the top. Let me just pin that. Okay. So who do we have in here? We got Sailor in here. Lisa, Karma Baby, Mary Beth. She's probably at work, aren't you, Mary Beth? Hey, Catherine. Welcome in. It's good to see you guys. It's good to see everybody. Hey, Ember. Hey, Reversed Images. And I am on both channels. So I'm on Unfiltered and I'm on my regular channel. I just wanted to see if like how because okay, so I couldn't like get it to like put on like the monetization, and I was like, why isn't it working? And I figured it out. So over on the second channel, and I'll put the link in the chat if you guys want to subscribe over there. It's going to be more of an unfiltered side of me, more just like laid back, kind of more chill. This is going to be more structured and more based, tailored only to to true crime. So I wanted to let you guys know that. So I won't be like double broadcasting anymore because I won't have to. So look at that. Here's to another 17 months. 17 months, Catherine. That's a long time. Thank you for being a member for so long. I appreciate that. Wow, that's a long time. I forget sometimes how long like some of you guys have been around. I love that. I love that so much. You become part of a family. So Ember, it doesn't matter. No, since I got my watch hours over there, I'm good on that. I just if you want to watch whichever one you want to watch, yeah, whichever one. My video actually did better on my second channel than it did on my channel, this channel, like last night. I was like, what? I was like, that's so weird. It was like another 400 views difference. But there's the link for the second channel. And I wanted to show you this article that I was reading earlier because I thought it was pretty interesting about Sarah. She will be going in court. Court starts in about 18 minutes, starts at 3 o'clock. So we have a little bit of time before she goes in. They are going to be, well, basically, actually, let's start with this just in case if you guys don't know. Sarah Boone, she is facing potential a life sentence right now. She is, if she's convicted, she is accused of zipping her boyfriend, George or Jorge Torres Jr., into a suitcase in the couple's apartment. She said it was a friendly game of hide and go seek that just kind of went wrong. She fell asleep. Next morning comes down and realizes, oh my gosh, he's in the suitcase and, he's dead. She didn't realize she had taken video of herself recording this. So she had recorded this the night before she went to sleep. The investigators find the video, confront her with the video during an interrogation or an interview. And she can't really lie her way out of that. So now her lawyer is trying to, and he's trying to get that suppressed and not put into evidence because he's saying that her Miranda rights weren't read right. So she's been in court, or she's been in jail since February of 2020, and they said no matter what, she's going on trial on the 7th. Thank you for becoming a member, Crystal. Thank you. So nice. Thanks. Which article is this one? Okay. I have a couple up here. So, but, what did I want? I wanted to read you a certain part. Okay. Right here. While no motions were argued at the hearing, this was the last hearing. The issue of the motions themselves came up because prosecutors have accused the defense of waiting too long to file them. And it says, which still need to be heard before the trial starts. Included in the motion is the one to suppress a 2-hour recorded interrogation of Boone at the Orange County Sheriff's Office. And then that's the one we were just talking about. We've watched that before. The warning consists of 5 sentences and 2 questions read to every person questioned by police for the interrogation to be legally and freely given. So, I won't read it all to you, but, you have the right to remain silent, all those things. So, Boone's attorney is arguing that the last sentence was never read to her. And I want to go back through that interview and see exactly what they say, because I know they're holding the card while they're reading it off of it, I wonder if maybe she had interrupted and maybe that's why they didn't say the last sentence, or maybe they did say the last sentence and this lawyer is just saying that. You never know. You never know. Especially when a lawyer comes in because of a piece of paper, Welcome in, PJs. Hey, Karen. It's good to see you guys. It's good to see you, Karen. Let's see. What else do I want to show you? I was going to show you her record. Okay. So she does go to court today. This is her record for Orange County courts. She's been in jail since it looks like 2/25/2020. That's a long time. I would want to get this. I would just want to get this done. I mean, nine attorneys, just so many things, so many things. All the letters, handwritten letters to the judge, the charade that she's been putting on. Oh, and another thing they have to go over is if she's going to get her hair and makeup done. So we'll have to see. We'll have to see. It'll be the first time in Orange County history that any defendant had their hair and makeup done for a trial like that. So I think all of this was just kind of like not really important. Oh, why did it take me to there? I think it's sign it again. Let me go back to her criminal sheet over here. Hey, wee gob. Yeah, this is going to be a good court hearing. So they're going to have to hear the motion because, I mean, she only has a few days. She has 5 days until trial. So the hair and makeup is going to have to be addressed along with the interrogation being thrown out. And after almost 5 years, I don't see them throwing that interrogation out. I just don't see it. This is the notice of provision of state supplemental witness list. Comes now the state of Florida. I think this is just showing what they're going to, who they're going to have on the stand or something. By and through the undersigned assistant state attorney and files this notice of provision of supplemental witness list, certifying that on the date of filing the instant notice of provision of supplemental witness list, the undersigned assistant state attorney electronically served upon the defendant a supplemental list of names and addresses of persons known to the state of Florida to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial. And it gives a section, Florida statutes that were discovered subsequent to compliance with gives the Florida rules of criminal procedure. So they're saying that they gave her a name of who they're going to call, I guess. I wonder if Brian's on the list. Do you think her ex-husband will be on that list? Hey, DM. Hey, classic one. Oh, Mary Beth, thank you. I have to pull that up so I can see what's going on over there. Let's see. Got 6 people over there watching. Yeah, come on in. Oh, Mary Beth, you did. I wonder if I can pin it. How do I do it over here? Oh, sorry, I got myself echoing now. Oh, Mary Beth was the first member over there. I'm going to do a live over there here soon too, because it'll be fun. Maybe we'll do something. We're going to do something more relaxed. We'll do something more relaxed. I think sometimes we need a laugh every once in a while. And that's where we can go and just giggle and laugh. So this is a notice of provision of witness list. This came out today. It takes me back to the beginning. I don't know why it's doing that. Like I should still be signed in. It's like every time I want to look at something. It's so weird. Okay. The next one here, I'll read it off to you really quick. I think it's, let's see. Same thing pretty much, I think. That must see. Yeah, it is. So those are her court documents as of right now. We are just waiting on her now to go into court. But while we're waiting on that, I wanted to show you guys something, and we may go over this case. Maybe we'll go over it tonight. But I don't know if you guys remember. Let me see if I could bring up a picture of a different picture of her. Let's see. Okay, let me pull it up for you. This girl here. We'll take a little detour while we're waiting. So, do you guys remember me showing you a picture of her? I thought I could have sworn I did at the end of a live. And if I didn't, I was sure thinking about her, but I don't remember if I showed it to you guys or not. But her name is Jessica Barnes. And I thought it was actually I thought we went over this on one of our like our true crime, updates, but I could be wrong, but I think that we did. She was missing. Yeah, unfortunately, so authorities in South Carolina, they are continuing their investigation into the disappearance of a woman who was last seen nearly 2 months ago. So she's 20 years old and she vanished from her Pendleton, South Carolina home. She was last seen on August 1st. She was last seen, I believe, by her boyfriend and their roommates. So I don't have a whole lot of information because I just saw it right before we went on live. But there was like a series of text messages that she sent, and her mom said, like, it doesn't sound like my daughter, that those don't sound like my daughter. And no one could find her. We couldn't find her. Well, I was on the Twitter, of course, and this comes up. So they found her. Very sad. Very, very, very sad. But I want to know because there's 3 arrests. So it says the remains of 20-year-old Jessica Barnes, missing since August 1st, have been found in Pickens County. And I want to know how far that is from her county. I'm going to look that up too. Shale Raymond, spokeswoman for Anderson County Sheriff's Office, confirmed that Barnes' husband, Brandon Barnes, was currently jailed at the Anderson County Detention Center. She did not say what he was charged with, but said Pendleton police would make an announcement soon. So maybe we'll wait for the announcement. 3 arrests have been made, and I found out, just looking for a second, that it was the boyfriend and the 2 roommates. So, man, it's just sad, I thought I reposted this. I could have sworn maybe I just didn't repost it from this one. Because I could have sworn I reposted it. Let's see. So I was I, I was trolling you and your YouTube channel or BOS. Look at this. So I went on to Cat the Hat's Twitter because I'm a troll and I want to know. And so he was like saying 2 months ago or a month ago, they've only been on here a month, he was like, we've finished phase 1 on to phase 2. And I was like, could you explain to us what was phase 1, like what you did in phase 1? And I was really nice about it, right? Just wondering. Well, then let me find his original message. I'm not good with this Twitter stuff, so I'll have to go to his page. I'm so bad with Twitter, actually. Let me see, because I was trolling. It says, today marks our 30th debriefing regarding the disappearance of Sebastian Rogers. Bullshit. And for once in my life, I am witnessing this marvelous teamwork and unity plow through the mud, cockroaches, and skunks. What? The team is making headway. No, you're not. And I'm honored, proud, and humbled to be a part of it. You could threaten me all you want. It's been done before and it'll be done again. But with me will go the house of cards. He's so friggin' weird. So I said, can you explain to me when you have searched in Tennessee for Sebastian? This isn't mean. Held a vigil, hung up a flyer, anything other than get on YouTube and threaten lawsuits. I am still waiting to hear what you did in phase 1. Guess a couple people didn't like that. They said, none ya. Ooh. They must have checked me out to see I had a YouTube channel. Like, Studio Mom. Oh, you're so cool. Oh, you're so cool. Oh, you got to put Christian first. Yeah, you know. And then you put in you're a POS. I'm going to put this on there. I just don't want to put it on here. Because that's stupid. I will be a troll to this person. So how do you guys think Jorge got into the suitcase? Do you think she rugged him or he was really drunk and maybe unconscious? I heard that he only weighed 102 pounds and he was 5'2" or something like that. So, I mean, I don't know how heavy he would be. Because I mean, I was kind of thinking that, like, how did he fit? He was really small, I guess. I'm gonna try to fit into Vincent's. I might have him get it out for me today, actually. And then we might do Jessica's case tomorrow. Maybe we'll do Sarah tonight. But I'm gonna try to, like, because I think that I'm bigger than him. If he's 102 pounds, 5'2", I'm 140, 5'8". I'm like a whole extra person, I feel like. But I know that whenever Vincent and I first got back from vacation, I tried to get in his suitcase. It's pretty big. And I didn't try that hard, I guess, but I tried pretty good. And it was hard. I couldn't get in there really. And I'm flexible. Like, I'm really, really flexible. I am proud of myself for that. Like, that's like one thing that's like hasn't, went to shit since I have all this, since I have all the metal in me, like the aches and the pains. I'm still pretty flexible. I got that for me. So. Okay, let's see. We're going to go over and see if they. Nope, haven't started yet. Man, they always put the best pictures ever on here, though. I don't think they got. Yeah, they got the noise in the background. So let me pull her up. It doesn't look like anyone's in their chat. Where's everyone at? All members only mode. Well, you're not gonna have very many people in there, probably. I thought about doing members only, like over here sometimes. We used to do it. I used to do it, like, on Saturday nights, like, last, like, 20 minutes of the live, we would do members, especially because it was, like, we were so busy all the time in here, so it was, like, hard to see the messages, when they're going by so fast. Oh, really, Savannah? Oh, I'm glad you're a member. And thank you, Mary Beth. I missed some stuff. Oh, you gifted one over there. It shows me over here. Look at that. There they are. They do show me over here. That's so cool. Oh, that's neat. You can and I can organize this better too. Hey, CJK. Welcome in, everybody. I thought I saw CJK in here. Are my eyes deceiving me? Thought I saw. Oh, I'm like all the way at the top. Where the heck is I at? He got involuntarily. You think DM in your opinion? I kind of think he did too. Like, so my first instinct is, maybe she got in at first. And it was like a game, maybe it was just sitting there and they were talking about taking the clothes to the Goodwill or whatever they're going to do with the suitcase and the clothes. And maybe they were talking about stories about how people, because there are stories out there about people shipping themselves, like trying to ship themselves to different countries in their luggage, and they end up unaliving themselves because they can't breathe, and then all this luggage is stuck on top of them. So I thought maybe she was like, let me see if I can fit, or maybe George said, hey, I bet you can't fit in there. She was probably like, watch me. So maybe she got in first. Maybe she even let him zip her up a little bit. Like, hey, zip me up just a little bit, like giving him that reassurance. And then she gets out and there's that trust there because she just got in a suitcase and let him do it to her. And she goes, you get in. Let me see what happens when you get in. Maybe that's when he gets in the suitcase and that's when she zips it up and doesn't let him out. Yeah, they were playing hide and go seek, but they were both seeking and or they're both hiding in the same spot. That's, that's not really the game. Oh, Dandy Patch, that's a cute name. I'm about to put this one over here. I need to figure out how to pin those. I'll have to get my other, maybe I can do it on my iPad. I'll have to get my other iPad. Well, actually, I won't have to because I'll only be doing it on one channel. I just wanted to see how this worked, like, just because even though I'm monetized, like, I forget the whole process. I really did. And I'm gonna get emojis and stuff over there too. They're just like regular emojis. There's CJK. I knew I saw. I knew I saw that bird. Yeah. I don't know why anyone. Well, maybe I don't know about the suitcase. I probably would get in one because I mean, I'm crazy. Um, but the videotaping of it, like, how did she not know that tape would be? I mean, it would be shown. They were going to see it. I just don't get it. Like, crazy. Oh, look, people are becoming members over there so they can chat. How many people are in there? They have 1922. I should join and be like, come to my channel, you guys. You don't have to join to be over here to talk. I wonder about the hair and the makeup. I'm curious. I want to know if she's getting her hair and makeup done. And if she is, I want my hair and makeup done too. Actually, I am getting my haircut tomorrow. And I ordered these boots. I want to show them to you guys when I get the dress. It's kind of country, I guess. I'm supposed to be dressed. Like, I don't know. It's a cute outfit, I think. I don't know. I'm bad at like putting stuff together sometimes, even though I own a boutique. Sarah said they were having a great day. Yeah, she did. I think it was a double dog dare kind of situation, and she was drunk enough that her switch, flipped once he was in there, and it went from there. Yeah, I agree with that. I can agree with that for sure. Yeah. Maribeth says, "I want my hair and makeup done as well." We all want our and Squeaky too. And they did have I mean, they did have history of DV. I don't know who was the aggressor. I mean, I know he was arrested more times than her, but you know how that goes. A lot of times the men won't call on the women, so she could have been doing it a lot more. Um, but I mean, this is just I don't understand how she could record it and sit there so nonchalantly. Was she that intoxicated that she didn't realize that he was really suffering and she thought he was kidding? Because to me, that doesn't sound like kidding at all. But, I mean, was she that inebriated where she thought he was kidding? I don't think it makes a damn difference. I mean, I think she's still guilty of second-degree murder, and that's what she's on trial for. So, I don't really know how long this trials really should take. It shouldn't take too long. I mean, bada bing, bada boom, show the tape. Show the interrogation. I mean, that's stacking them high. That's stacking them high on Sarah. What else does she have? I wonder if they're gonna notice the shoes. I know I talk about it, but I notice those little things. It felt like she just threw those shoes over there too, like trash, like, "Get out of here." Um, and I mean, I feel bad for Jorge. I feel bad for him. That's no way to go out. Not being able to breathe is, like, the worst feeling in the world. I, Yeah, it's the worst feeling in the world. I collapsed a lung and I couldn't breathe. And, oh man. So I couldn't imagine him. They had to like take emergency surgery and I was in ICU, but it's slow and panicking. Yeah. And you can tell like he was panicking, but then like he was like almost like trying to get his breathing, like stabilize his breathing. It was sad to listen to that tape. I've only played it a couple times on the channel because it's everywhere and it's just real disturbing. I'm so ready for the trial, someone said. Me too. What's her lawyer's name? I forget. Court Insider. The defense has filed a motion seeking to suppress the 2-hour interrogation that Boone did at Orange County Sheriff's Office. What the heck's going on? Why aren't we watching it? Oh, wait. There we go. Sorry. I don't know why I was back there, but good thing I was reading that. Oh, yeah. He hasn't been on yet. Okay. It says Court Insider citing an incorrect reading of her Miranda rights. Both sides have said they plan to call witnesses. Also expect to be discussed at the hearing is Boone's motion for professional hairstyling and makeup. Like I said, yeah. Someone said I'll do her makeup like free like this with the clown. I don't think taxpayers should pay for that. Yeah, I don't either, but I mean, I wonder if what's his name is going to write this off as a her lawyer, like he's going to buy her clothes or whatever he said. And so she doesn't have to wear like the jail like they have a box of donated clothes street clothes that people can wear and of course she's not going to do that. So he was going to take her measurements, her lawyer was, and get her some regular clothes. I wonder if he's going to write that off as like a business expense. Wonder how much you get back for that. I have a business. I need to start writing our stuff off. Always forget. Hey, Love Summer Moon. Levin Summer Moon. I said your name so fast. I was like, said right through that. And see something, say something. How you doing? Yeah, you're right. Yeah, that's what she said. Dared, yeah. Yeah. I think it was something like that too. I don't think it was no hide and go seek. I don't know why she just didn't say I dared him to get in. I mean, like a dare. I don't know. Now, if it's a double dog dare, then I mean, I could see doing it. But just a dare. Oh, okay. I'm the worst at names. Give her a brush and Cheeto dust. Yeah, it was good enough for Lori to take that. And, like, yeah, just get her some Kool-Aid packets or something. She'll be fine. Oh, wait, why does this keep going backwards like that? See? Doesn't want us to be on time. Like, are we nothing worse than somebody that's, late. Like, why are we late? I'm just putting this over here so that we can see the chat. After it goes on, I'll make it full screen. Did James Owens that's his name, James Owens, get Sarah's measurements taken yet for her trial clothes? Probably. This is scheduled to be the final motions hearing before her murder trial begins Monday, 10/7. So, yeah, Monday. Get ready. We will be covering the trial. I'm going to we'll put a poll on the community tab and just make sure you go vote on it. I'm going to say, like, ask if you guys want me to cover the trial or just cover updates. And then, yeah, we'll go from there. I'm going to put it on the community tab today, right now, in a minute. What's going on? Something going on? What are they doing with that camera? Hey, where'd they go? What she do? Not show up? She refusing to come? And okay, yeah, what are you gonna do with this hair? Uh, what are you gonna do with her hair to make it look better? She can't go any shorter. Do you think putting a perm in it? Give her a little perm action? What this is scheduled to be the final motions hearing. Okay, never mind. I'm gonna make a banner. Making a banner. Final better be motions hearing for trial start. And okay. Well, this is just crazy. Hey, Citizen Sleuth. It's like all quiet in here. I feel like it's really quiet in here. I was just putting that, I was getting that pull up. I'm just gonna write this out really quick, sorry. Why y'all late for? Because you know Sarah's gonna take forever. Okay, let's get a poll here. Next time we're gonna Make sure they're on. Make sure that they're on. I can always read over her documents and stuff too. Let me do a poll for us. Does anybody have any cool plans for the day? Do anything fun, anybody? I have to take dog collars back. Actually, I might do that tomorrow because I'm getting my hair cut. It's over there. I just need to drop them off at the Kohl's because I gotta go back to Amazon. I bought a medium and a large, and they don't look very big. I don't know, they just look kinda I don't know. They're supposed to be like leather, they're leather, but they just don't look as very good. I don't know. So I figure I'll get new ones. Oh, uh-oh. Let me make sure this is up. Gotta stretch your legs, don't you, lady? Let's see. Oh, this is a little behind the scenes, I guess. Oh, we don't want behind the scenes. We want people to get in here. Where the hell is Sarah Boone? Fixing her hair and makeup? I swear, y'all, if she comes in here with a new hairdo, I'm gonna fall about my chair. I'll be falling out of my chair. I'm sorry, I will. I won't be able to like handle life. Hey, Pooh Bear. I think we could give her a perm. Hell, I kind of want to get a perm. A wig, good, yeah. I was gonna say extensions, but those are too damn expensive. You know what I mean? And wow, yeah, she would need some real good ones too to be working with that little bit of hair. New court clerk alert, bang, your gavel for at Carly Dunham. Okay. Oh, is that the lady? Yep, that's the lady cop. That's always in there, isn't it? Or no, that's the guy. I thought it was a lady. She usually comes in with her hair pulled back in a bun. Thought it was her. So she sits over here, like by the door. I always want their job. They get to like hand the papers off, the paperwork off. That's all they do is just like hand the paperwork off, make sure the court like stays cool, calm, and collected. And they get to hear all the good stuff, all this stuff where they're like, turn your mics off. They get to hear all that. I want to hear that. Yeah, could get her a wig. Could do that. Sorry, sir. I'll call you a lady. Definitely not. On your computer. Why? I mean, I don't understand why people super chat big, 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 big creators like this. I mean, it's court TV. It's not like it's you know, uh, I don't know how to explain it. Like that money should maybe go to like their interns or something. You know what I mean? 'Cause I'm sure that they have like interns helping them with like their channels. It says, "Wait for it." We have been. So yeah. So today they're going to listen to motions for the hair and makeup, and they're going to man. And they're going to hear motions whether to suppress the interrogation that she had with the officers the day after Jorge's death. So we're just waiting on her to come into the courtroom or her lawyer or anybody. I don't know what's going on. But it's been almost 20 minutes, like 3:18. What's going on, Boone? I mean, they're usually pretty like on time. Like, I'm wondering, nothing going on. Trying to see if, I could find anything online. I'm gonna look on, Twitter, see if there's anybody, like I don't think they're I don't know if they can have their phones in there, but I saw that True Crime Lullabies. That's where I'm getting my hair cut tomorrow. I do not need to be in there by myself. I don't. I have so much makeup. I don't even wear makeup. I mean, I even have the airbrush makeup. I'm gonna need makeup for the wedding. I don't know if I have my color. If I have every color. Let's see. Sarah Boone. Why aren't you in court, girlfriend? Oh, here, we can watch this little trailer for her. Oh, for her court hearing. Oh, there she is, Emily. Hold on. There she is in all of her glory. Let me turn the volume up. It's up. Make sure you turn your volume down a little bit because it's up all the way, and it might come on if you're wearing headphones. It might hurt your ears. She's in her jail clothes, so maybe she just wants to wear them for court or for trial. Oh yeah, she's not gonna have her hair done because they're gonna talk about that today. Sarah, you should have just grown your hair out again. Ulta is a makeup store, and they've got all the makeup and skincare and hair care that and everything you'd want. And they have a salon in there too, and let me tell you, their haircuts are not cheap. Not at all. I'm like, I'm used to my sister-in-law doing my hair for free, so, you know, almost $100 is pretty damn expensive. But I'm not getting my hair cut anywhere else because this girl did such a good job, and the girl before her, remember, butchered my hair, so I'm too scared. I'm only letting this one girl touch my head now. So I'll pay the extra just to know that reassurance. I'm just getting it trimmed. I'm not gonna come out looking like Sarah or nothing. Yeah, well, by the time you tip and everything, it's almost 100. It's probably like 80. 80, yeah, about 80. But they do a conditioning too at the end. Oh, I wish I could cut my own. See, I'm too scared. When it was I would've, but now that it's short and someone butchered me, that's why my hair's so short. I'm too scared. And so, like, but the girl that did it last time is so, so nice and so sweet, and so, um, and I tip really well. My mom was a server, I was a server. Um, I just whenever people are on their feet all day, I can't imagine working those kind of jobs. Yeah, yeah, true crime lullabies, yeah, it's kind of expensive, but I mean, it's an experience. They give you, like, I mean, they're good to you. It's like a good experience, like when they wash your hair and everything, and, I don't know. Why are we hearing them? They're just, like, signing papers, I guess. What are these papers we're signing? Is she taking a deal? I'd fall out of my chair if that happened too. Pooh Bear, you were a server too? You know what it's like then. The I loved being a server, I didn't mind it, but I hated Sundays. I hated working Sundays. I quit on a Sunday, I hated working Sundays. It's very unbecoming. I don't know why she decided to do that with her hair. I mean, it was always short, but not this short. Yeah, there's not much you could do with it. Man. So, I was, talking to one of my best friends today about her wedding, and they wanna go out after we eat. We're gonna have the wedding, and then we're gonna have dinner, and then we're gonna go out. And, well, the hotel, I guess, has 3 bars, so I don't know if we're gonna stay there or actually go out, but if we go out, the bars around there is downtown OSU campus bars, and so I'll be the oldest person in there, one of them. Um, that's okay though, but I haven't been inside a bar in 7 years, and then before that, it was, like, 3 or 4 years. So, I mean, I don't even know. I'll probably, end up in a fight because somebody's drunk bothering me or something. Just kidding, I wouldn't. I'm just kidding. Very bad. It is expensive. I think that though, I kinda justify it as I never really had to pay my hair for my hair done before. My sister-in-law always did it. Wait, son of a bitch, why didn't I just have her do it? I'm going down there. Well, technically, I'm not. Yeah, no, just I'll pay it. I'll pay it. Um, she used to do my hair for free, but, remember when I got it done though, Mary Beth, at Penny's? I got it done at Penny's. It was like I got it colored and I got it cut, and that woman, um, she cut my hair like it looked like it was, like, zigzagged. Isn't that about being drunk? It could be. I do know a lady, though, that used to pay even more than that. Like, this she was like my mom, like, and she had beautiful hair, but she would pay, I think, 140 for haircuts. I'm like, "Oh my god." At the time, I was freaking out. Now it's like, I just pay it. It's like 80, but it's still a lot. And I don't get my hair cut very often. I mean, I got it done in April. I'm just trying to, get it cut now because I feel like it's falling out. Like, I feel like my hair is thinning, and so I'm trying to, like, keep it up like, keep up on, like, cutting it and being good. Yeah, I know, right? Citizen Sleuth, if I come on here and if I start a live and and you see me getting arrested, I'll scream out the town. I will be at Ohio State on campus. "Someone come and get me." I know Vincent would never leave me in jail, but, I could see that happening if I had some tequila in me or something. Or maybe no drinks at all. I probably won't even drink. I'm just there for the food. Um, we're gonna go out to dinner, but I heard the place is, like, really, really good. So we're gonna go eat, and I'm excited for that, and I'm excited to stay at the hotel because it's super expensive, the room was, so we might just go back to the hotel and, like, swim, me and Vincent, like, go to the bar for a minute. I've asked Vincent before to cut my hair, he wouldn't do it. When it was long, I was like, "Just cut it, like, straight across, Vincent." Like, he would probably give me a really good haircut. He would look it up. He would figure it out. Oh, really? I hope that's not what's happening to me, True Crime Lullabies. But, like, I don't know why, but it just feels like it's getting thinner, and I use Nexus, like, I use good shampoo and everything, good conditioner. I thought that's good anyway, and so when we were at Sam's the other day, they had this, like, three-in-one care system. It's supposed to make your hair appear fuller. Um, it was, like, 2 small bottles compared to, like, the 2 of the big bottles for the same price, and I don't feel like I see a huge difference. Yeah, that's what I need to do. I'm gonna take some vitamins, I need to get some this weekend. I know you guys would see JK. I would be like, "Come help me, guys." Hey, I might end up, going live, you never know. I might just do it just so you guys can see what I want you guys to see me in my dress and stuff too. I'm gonna look all pretty. I'm gonna be all dressed up. Well, I hope I look good anyway. I told the wedding gal today. I said, just whatever you need me to do to make your day like, easier, just let me do. Just let me know. Called doTERRA? Oh, I've never heard of that before. Yeah, it's the stress, I think. That could be a big problem. I stress a lot. But I did make some good food today. I got chili on the crock pot. I was in the kitchen at 9:30 this morning. I couldn't even believe myself. Pat on the back to me because I don't ever cook. Like, ever, ever. Um, like I tell you guys, Vincent usually cooks, but I wanted to make sure I don't know, I wanted to cook for him today. Wanted him to come home and the house smell good and, you know, 'cause he does always cook for me. Plus, if I cook for him, maybe he'll cook for me tomorrow. What is going on here? Are we the only ones not listening to this? I don't even know. Like, nobody's talking. What are they saying over here? Sarah Boone maintains her innocence as she is interrogated. Okay, never mind. I don't want to watch that. We want to know what's going on here. Like, I don't hear anybody go in the chat going like, why can't we hear? But nobody's saying anything. I don't know. It's weird. Like, where's the judge? Okay, maybe we will play this. Oops. Okay, well, let's get some coverage started now. Oh, wait, there's the judge. Let's see. Turn on that microphone, buddy. Sorry, it was 31 minutes late. Oh. What do you say? I'm gonna pause this for 1 second. I hope that we don't have the horrible sound like they did last time. Hold on a second, guys. For some reason, it lost the sound.
CSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got the two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or
Yeah, if you look
Fine.
in the very back,
He's calling his bluff.
if you look in the very back,
Okay.
you see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes.
Where's he going?
I also have
forgot to start the
reviewed
poll.
the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, state, you may proceed.
State would ask the court or the clerk to mark A for identification as a DVD, courtesy copy, body worn camera.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection.
What was pre-marked as states A will be received into evidence without objection as states 1.
It still goes on, Squeaky. He said no delays. Trial is going on with or without our attorney. They ain't messing around. Kranick isn't messing around. Judge Wooten did for the last 4 years. We got a new judge. There's a new judge in town. There's that detective lady. She looks good.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Council, Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene, we notify the call center to notify the on-call. Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, it's not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but I should be able to.
Prior to that, had she been detained and requested not to leave the scene?
Right. One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potentially child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to the window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And
Let me see if this one's better. Hold on. Shit. Don't know where I put it. Okay, was it? All right, let me find it.
your testimony is it wasn't you.
I don't believe so, no.
Now tell us about these interview rooms.
Have you had a chance to
This is
review
better, I
any
think.
paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver
probably had a
to
moment.
consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know, there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is, at some point, you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct.
Nope.
Sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay.
She didn't need her. She's just having a
Did you
conversation.
tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah
She didn't
before
know
y'all
about
got
it
in
in
the
the
vehicle?
car.
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have
Why
to
would
tell her
you?
something.
I said, yes, we're gonna go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you
This
said
lawyer's
this
terrible.
is routine protocol to come into the car and talk to me?
Those words specifically, no, but
Okay.
I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're
Nobody
getting away from the
reads that
card to now
part.
the policy. There's nothing about the policy right now. The question is about what the card says.
The card is the policy, and the policy is the policy. They're intertwined. They
Oh, my
refer to
God.
each other. Um,
The policy's the policy.
Our argument is that she did not waive her rights to
But
remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her
No.
not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February
didn't need her to
24th or on
talk.
February 25th?
On February 25th. This interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant. And I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card. But continue.
I'm sorry?
It's not on my Miranda card that I read from. You can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there's that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together or were you making all the calls or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know. off the top of my
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
head. Yes,
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner or were there anybody else there?
I don't recall if Detective Yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her.
They didn't
So
have her
that
phone
if
yet.
she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect. They had probable
What does that
cause.
have to do with
Yeah,
any
yeah,
of the three
right.
issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day,
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first.
Okay.
The objection is sustained.
Okay.
You may proceed.
all right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
She was not,
Excuse me?
she was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. And it was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
objection, relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the two videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time?
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
You may.
If you would, see if you recognize that document.
Yes, this is our waivers and affidavits.
Is that a filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah?
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Sorry, guys.
Yes.
Is that your signature or what?
Yes.
And is that
I was sharing too many screens. Sorry.
for the,
Oh, yeah, the closed captioning is on.
The consent to search, yes.
It's closed captioning has been on.
Yes.
that is a form that's standardized by the sheriff's department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
Okay. You would agree that there's 9 questions on the form?
Yes.
Judge, I would like to offer this.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that.
Yeah.
So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell?
It's like it's saying made in China on the card, and they didn't read made in China.
And then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant, It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card.
Considered
still,
by,
I feel
Denied.
like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern Third 197, and Owens 41, Southern Third 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
what the heck just happened to him? What? What the heck just happened?
that on the 25th, when you were reading her
Why
Miranda
is it so
and about
dark?
to question her, was different from the situation the day before
Man down.
when you read her Miranda in the squad car?
Let me get the other one up. Let me get Court TV up.
That was without the autopsy. That was without the two videos from her phone in the squad car.
Yeah, I did at the time of the interview.
Yeah.
Yes.
And in the squad car, she was free to leave.
I mean,
Dark
I didn't
over
know
there,
she was
too.
really, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay. That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you. State,
Why do they need a recall her?
you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. All right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. Just that one.
Man, what's he doing? What's that big old freaking book he's got?
What is it that's been marked
Manifesto.
as Defense Exhibit B?
Sarah, what do you have your lawyer doing? What do you have him doing? She's like, I should be touching papers too because they're touching
Any
papers.
objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same arguments I've made.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, judges the policy of the sheriff's department.
I'm glad she has him, actually. I mean, I don't know. He sucks. He sucks, but she doesn't have anybody. And I'm I'm an empath, and you know, even though she's not, I'm an empath, and I don't know, when he just, like, you know, he put his arm around her, I felt bad. Like, I mean, you know, she shouldn't have been representing herself, even though he's not much better. Maybe with both of them together, they can.
Do you know what page
Maybe we should
specifically those policies are on?
Page 14 of 22. And I'll give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
Wait, why are we moving Sarah? Is she going up on the stand? Oh. What? What? Oh, what? I didn't expect this. I didn't expect this at all. We can see the front of her face perfect.
Ma'am, you've already been sworn. Counselor, you may
Say your
proceed.
name. Oh, dang. I want her to say her name and spell it.
And would you please state your full name?
Oh, there it is.
Sarah Boone.
Well, you're
Full
going to have to
name.
speak up or move the mic.
Sarah Boone.
Full name.
Yes.
Supposed to be my middle name, too.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase.
Don't you act now.
You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to
That-
suppress.
yeah.
They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But we're,
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
She is a kid that she was supposed to pick up the day that, she called her ex-husband Brian. Their son stays with Brian, her ex-husband. Yeah. Mm-hmm. She was a very absent mother. I'm going to say that because that's what Brian said. Brian said she would show up here and there. She had an alcohol problem.
It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
I think her child.
Did you speak to the deputy about
what his mom's going through?
what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection, calls for- she's back up.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes,
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No,
Did they ever indicate to you that you were a person of interest?
no,
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time,
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. Irrelevant. what your statement is.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her,
Objection. Answered.
Overruled. You may answer the question, ma'am.
But I didn't call for a yes or no. She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No,
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
yes,
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a very small room and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No,
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
no,
Okay. So directly off the elevator and walked into the interrogation room.
correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes,
You recall that happening.
yes,
Did that refresh your memory watching the video?
yes,
Do you recall her saying that she had received the autopsy?
yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
And she also said, we're not done talking about the incident. You recall that?
Yes,
And then she said, we just have to do it.
yes.
How did that make you feel?
Objection. Relevance.
Sustained.
Were you trying to comply with the officer's demands?
Objection. Relevance.
Overruled.
In every way,
Were you trying to cooperate?
in every way,
Were you polite with them?
very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes,
And then you said normal protocol.
yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes,
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights,
My
you.
Lord.
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asking
She
questions.
said she
Is it fair
understood.
to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to whether or not.
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me,
What's the subjectivity matter under the case law?
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Should have said this 4 years ago.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
She should have.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
She wasn't in her home.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what it
What are the
was.
legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
He's still drunk this many
And you
years
understand that
later.
you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
No, that's exactly
Your
what.
intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The 2 prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to council's table. While she's in the process of returning to council's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Denied.
Mr. Owens, it's your motion, sir. You may proceed.
We haven't even went over the makeup and hair yet.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement
They
to
didn't.
correct that type of misuse behavior. It's illegal. So you've got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. if she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
We have
The
to
United States
respond.
Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, those 2 exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that
Already
issue.
discussed it.
I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless
Yeah.
there was some sort of
Like
change in
shackle.
position or authority, then the court should maintain the law of the case.
Response.
Don't ask for no more.
Clarification, but she's here today and she's in handcuffs, so she has difficulty writing. She has.
Oh my
Let me
God.
just interject for 1 second.
We already know.
She will be hands-free.
Okay.
So the
She'll be hands-free. She'll have the restraint on her damn leg. Move it along. You need to learn the case, buddy. We already did this when Sarah Boone was her own attorney.
issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of
Don't see her
innocence.
feet under the desk.
And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative. And she understands the importance of behaving. And I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe so.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the security
He was
areas.
supposed to already have her
If you want to
measurement.
attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints, but the hand restraints will be removed. I think that it falls under the same
Okay.
analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, oh, I'm sorry, yes. Yes. So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
What
Yes,
do you
my
mean?
JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the, and listing the, I think it was the,
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against
Yeah, because she didn't show up.
Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed.
Well, it doesn't matter. They were
I believe
dismissed.
It's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme.
It's because
So
the spouse
ultimately,
does
the jury
it.
is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
to whether or not it was a
if it comes
decision.
out, if it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't
What?
have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims.
They didn't
but it was
consider
their
him a
decision to
threat.
drop it, and their
Not big of
power
a
and authority
threat.
to do so, not the victim's authority.
Okay. Response.
Oh, don't even respond to it. It's dumb.
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes
He's
that
not smart.
arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case.
Yeah.
That is opinion work product. And if they want to get public records about these cases and
This
try
guy's
to
horrible.
get them
Her
moved into
lawyer's not
evidence,
very good.
then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the
What?
Advent Health records that have documentation that Billy Lane picked them up in 2021.
Wow.
Defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching
She had
the
that
victim
cell
on how
phone
to
those
drop
years
charges
ago?
against her on her phone. So
Oh
all
my
that
God,
evidence
this
is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not
Well,
not
that's
the victim.
stupid to interrupt their time
Not
for
why
this.
we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
So why need a victim's
You
advocate?
have a written order on the motion.
Get outta
protective
here.
order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon. It appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they
That's because
file
your
some type
client
of
took
motion
forever.
about that,
Her time's
some
out.
motion
Her
about
time's
that,
done.
hearing on that.
Okay. If you go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance
cross
where, as the
that.
court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all. Which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m.
Monday
recess. Thank
morning,
you.
9 a.m. Whoop, whoop. She's writing. Leave her be. I want to see if she does anything cray cray. Wait till they cut that feed. She got her pen back. You smart. Yep, smart. Got that pen back from them. Yep. What you doing, Boone? Oh, bye, Boone. Oh, wow. Okay. So I think they're gonna give her I think they're gonna do a leg restraint for her and just shock the crap out of her. But I don't remember if they even did gave us an answer on that. He wanted to get the leg restraints off because he said that they could see it from the jury box, even though they're on her feet. And there'll be something, I guess, in front of the table, like where you can't see under the table. That was what the judge was saying. But they did tell her that she could have her hair and no makeup, I guess, but have her hair done. She could have her hair done, I guess, by somebody, one of the lawyers. Now, the two lawyers weren't there today. I wonder if they know that their boss just volunteered them to do hair and makeup for Sarah Boone. Because if that was me, I'd be like, I quit. I'm not freaking doing no hair and makeup for nobody. I can barely do my own hair and makeup. You should see my hair right now. It looks crazy. But our arms aren't going to be shackled. Yeah. So, and then the clothing, he has to bring the clothing to the jail for her. They're not going to dismiss any of the interrogation. That's what he was wanting to do. He was wanting to get that suppressed, and they're not going to do that. And they're going to have a virtual meeting tomorrow. I don't think that's going to be broadcasted, but I'll keep my eye out. They said early in the morning, and then at 3:00 they're doing something else, maybe virtually, and then Monday will be the trial, Monday at 9 a.m. Oh, I thought it was opposite. No makeup but hair. Because they're afraid whatever they put on her face that she would walk out with it on. Did I hear it wrong? I might have heard it wrong. I'm sure we'll hear it again, I'm sure we'll hear it again. But what was I going to say? I think I'm going to come on later and do their Nancy Grace just popped out a new podcast over Diddy. So maybe we'll listen to that later this evening if you guys aren't doing anything. It looked like it was going to be pretty entertaining. It says 1999 Diddy molest you. Over 100 sex assault victims alleged. 1999. Wow. She's probably in rare form. I don't think that there's anything else. Just the stuff with all the storms and stuff. It's so sad still. Everything's so crazy. Let's see. I don't see anything, but I will be back on later. If I don't see you, I hope you guys have a great day. If I do see you, I'll see you later tonight. But I'll make sure that I'll make sure that I put up a thumbnail for you guys here soon. Right, lunch lady. Yep, that's true. Oh, wow. See something. I guess, oh, somebody caught him with the copyright. Wow. That makes my belly hurt. I don't even like thinking about that. Yeah, it was probably for reused content, but I know that's what it was for. Wow. That sucks. For any creator to But thank you guys for being here. I do appreciate it. But I'll be back on later tonight. Like I said, I'll see you guys all tonight. Have a wonderful day. Bye, guys.